others to judge, which we submit happened here. Constable Metcalf knew that he didn't have authority to enforce the motor vehicle code, and he indicated that he didn't think he had authority to detain beyond carry stop. He stated as much at the hearing. That's why he called PSP, and that's why he called the on-call district attorney for instruction, for clarity, and maybe for cover. Thirdly, it's clear the constables acted under color of law when they detained the appellant, and that detention tainted the subsequent events. In McGavin, Pierce, and Corley, to an extent, the court was looking for that something more that converted a private party into a state actor. Once again, here, within 4 minutes of the encounter, the constable who was wearing a badge and carrying a visible weapon had a direct line of communication with PSP, had the phone number of the on-call district attorney to call, and he received explicit direction from the DA to detain the appellant so that the police could arrive and investigate a more serious crime, i.e. DUI. This isn't a case where the constables took down the defendant's name and his license plate and tendered that information to law enforcement later. This is a case of real-time direction and detention. As such, we submit that the exclusion is the proper remedy. And lastly, I'll finish with this. Every day in the Commonwealth, concerned drivers call 911 to report accidents, and PSP are dispatched to investigate. They don't refer the caller to the on-call DA. They do not direct the citizen caller to detain that person until they can arrive. And this case should be no different.
Thank you, Mr. Royer. Well done. And we'll hear now from Topper.
Yeah, Chief, may I ask?
Oh,
Chief?
sure. Sorry. Yeah.
I was a little delayed there in my
That's okay.
muting, and my apologies. Counsel, did this constable have any authority to make an arrest for a breach of peace outside of New Oxford Borough?
Not according to statute, no. Any power to detain he would have had outside his jurisdiction, as my understanding, would have to be consummate with that of any ordinary private citizen.
Well, what difference? I mean, that I'm a little bit confused by that argument, because if the statute says that a constable only has authority to make an arrest for a breach of peace in the borough in which he is a constable, why would he have any other powers of an ordinary citizen or not?
In all fairness to the Commonwealth, I don't see where that power has been abrogated by statute going back to Lead. In other words, I can't argue that he doesn't have the authority to detain someone to halt a breach of the peace like that of any ordinary citizen.
Well, let me ask this question because I'm confused by this, and if there is this general power to arrest for breach of peace that just sort of exists in the ordinary citizen, why would the legislature be talking about giving the constable the right to make an arrest in the borough in which he is a constable? Isn't that a limitation as opposed to an expansion of powers?
That certainly can be argued. In fact, constables' powers, as they've developed through Anglo-American jurisprudence, would lead to that. They've most often been a creature of statute. So that certainly makes sense.
But of course, you didn't raise that issue below, did you?
Your Honor, no, I did not.
Counsel, Justice Baer, Justice Donahue makes a good point. The only reason we have this case is based upon your statement of the issue, is and is consistent with your argument, is that Your position, if I understand it, is that once the breach of the peace isn't completed, and the constable no longer has any authority, and therefore the constable could not hold your client. Is that accurate?
Absolutely. And that's whether or not that would be, once that breach of the peace is concluded, there is no reason for him to intervene. And it's very clear from the record, and as the stipulations of fact agreed to by the parties, he's holding my client at the direction of the prosecutor to investigate for an unrelated, well, maybe not unrelated, but a different crime altogether.
If he, now let's assume for a second, and I think the record bears this out, and I know there's stipulations, as you just said, that your client was substantially intoxicated, that your client flew his car from the highway over a roof and into a backyard, and the constable watched all of that. The constable approaches your client. Would you have the same argument if they were an hour and a half from the local magistrate and he drove them to the local magistrate for arraignment?
I don't think so. I think that's the rub. I mean, those are all actions the constable could have taken. There was no presentation to the magistrate. He was detained waiting for state police to arrive, which is a significant difference in my mind.
So your position is not that an hour and a half is an unreasonable delay. It's that you can't wait at all for a law enforcement authority to come. What's he to do? Let the drunk, I mean, I don't mean to be pejorative, but let somebody who's intoxicated drive away or walk away?
Well, in this case, there was an alternative, and that was to call mom. Mom comes, picks him up, there's a tow truck that could be called. There's all these ways that could have alleviated the situation short of detention. And it wasn't so much that it was an hour and a half, it was indefinite. The record shows that when the constable spoke with TSP, they didn't know how long it was going to be.
Let's assume for a second that it took Mom an hour and a half to get there. Any difficulty now?
Once again, Your Honor, under the circumstances, I don't see how any amount of time at the direction of the district attorney's office is acceptable. The constable is, at that point, he is acting as an agent of the state without the necessary and proper training in order to investigate.
And his only other choice is to, if you can't wait for Mom, is to let the intoxicated person walk or drive away.
Well, so the record is silent as to the ability for the defendant to drive away. We have no idea of the condition of the car. We do know that it went flying through the air and landed in this yard. We don't know if the car was even operable. The record does reflect my client was intoxicated, but it shows no desire on his part to leave, no efforts made at leaving.
All right.
To the contrary, he was deemed affable and asked for a ride home.
Thank you very much.
Okay. Thank you, Mr. Royer. Mr. Topper.
Sure.
Good afternoon, Your Honors. May it please the court. My name is Dan Topper, and I represent the Commonwealth of Pennsylvania, Aplt, by and through the District Attorney's Office in Adams County. Applt's contention in this matter is that the evidence obtained following the arrival of state police should have been suppressed. This contention is based upon a potentially twofold rationale. Firstly, that Constable Metcalf lacked the initial authority to detain appellant for a violation of the Motor Vehicle Code. Secondly, that appellant's detention for an hour and 20 minutes waiting for the arrival of state police was illegal and therefore tainted any subsequent arrest by the state police. The Commonwealth respectfully submits to this honorable court that both of the appellant's avenues of attack must fail in this instance. As to whether Constable Metcalf had the initial authority to detain, the Commonwealth first submits that the question is beyond the limited scope of the allowance of appeal in this matter. The issue granted by this honorable court is whether or not the constable could continue to detain the appellant following the initial arrest for breach of the peace. However, if the question of initial authority is to be considered here, the facts of the instant case distinguish it from cases cited by appellant. Here, the Commonwealth does not contend that constables have the authority to enforce the motor vehicle code. I believe it's plain to see from precedent that that's not the case. However, the Commonwealth maintains that the initial detention was an arrest for an ongoing breach of the peace, consummate with the authority of any private citizen to detain on such grounds.
Could I jump in there, counsel, and ask you, because you mentioned an ongoing breach of the peace. Suppose that before the constables could arrive, he had just abandoned the scene, walked away, left the car, and they could. So there was no ongoing breach under that circumstance. He just walked away. They weren't there on the scene yet. Could they have pursued and detained him in that circumstance, or could they not, on the theory that the breach had ended?
Your Honor, I believe that would be a highly factually dependent scenario. I think in the case that he gets out of the car, the keys are somehow lost, the car is determined to be definitively inoperable, and he's incapable of walking away from the scene. I think you have an argument that a breach of the peace can't be ongoing because there's no potential for ongoing harm to persons or property in that scenario. I think there is potentially that argument.
Okay, thank you.
Counsel, it's Justice Donahue. Was he detained because of a breach of the peace, or was he detained so that he could be arrested for a motor vehicle violation? He was never charged with breaching. There is no breach of peace, but he was never charged with disorderly conduct or public drunkenness or anything that a constable would have within his or her purview. I mean, he was essentially charged with DUI.
Sure, Your Honor, I think that's an important thing to talk about. I think when you're talking about scenarios which give rise to breach of the peace, you're often talking about concurrent crimes under the Crimes Code or concurrent motor vehicle code violations. I don't think they're necessarily mutually exclusive. I think when you're dealing with breaches of the peace, for instance, I brought up in my brief, if there's a gunman standing in the square waving a gun around, you're not only dealing with a breach of the peace, but you're also dealing with simple assault by physical menace. You're dealing with potential terroristic threats. I don't think that they're necessarily mutually exclusive, and it's highly factually dependent.
Thank you.
Okay, Mr. Royer, we certainly understand the arguments. Did you have anything else you would like to add?
Your Honor, this is Attorney Topper. I have nothing else I need to add for the Commonwealth.
I'm sorry, Mr. Topper, yes.
Other than I do also want to point out in response to the appellant's argument, I think that there are things factually of record that point to the fact that if the constable hadn't stopped that he would have left the scene. The car was running when the constable walked up to it. Additionally, the appellant said he was there to see an individual by the name of Vic, who the constable knew was not in the home because he had been in the home. Therefore, there's every reason to believe the appellant would have realized the person wasn't there, got back in his vehicle, and continued on his way. I think that there is significant facts of record to point that there was the potential for ongoing harm to persons and property here. And therefore, I do believe that the arrest for an ongoing breach of the peace was valid, and therefore any subsequent arrest and investigation by the state police should also be valid.
Thank you, Mr. Topper. What threw me off a little bit, you were kind enough to share the podium with your colleague, and Mr. Royer's name's on my screen, but I know you're Mr. Topper, so thank you.
I'm sorry, Your Honor. I just wanted clarity for everybody.
Thanks to both of you. We'll take a brief recess and then call the next case.
The next matter is Robert Kirksey Jr. versus the Children's Hospital of Pittsburgh. Representing Mr. Kirksey is Mr. Jason A. Archinaco. Representing the Children's Hospital is Mr. George P. Kachulis.
Good afternoon. The case involves a medical negligence action where testimony was admitted at trial concerning the disclosure to the patient of risks associated with taking a particular drug. At the conclusion of the trial, he requested a jury instruction stating that assessment of the risk is not a valid defense to a claim of medical negligence. Trial court denied the request on the ground that the defendant had not raised the assumption of defense. The issue is whether such an instruction is required. Cases where evidence of risks and complications is admitted at trial to establish the governing care. That you may commence your argument.
Thank you, Your Honor. May it please the court, I'd like to reserve 5 minutes for rebuttal. As a preliminary matter,
we don't have rebuttal, so we ask you in your argument, please anticipate any that you think will be presented by.
Understood, Your Honor. Understood. First, I would like to say that I have advised Mr. Kirksey that this appeal is by permission and that you had to grant it by permission. Otherwise, he would be bound by what had occurred at the trial. So Mr. Kirksey is appreciative of the fact that you're hearing this case. And I would also like to say that I am personally appreciative of the fact that you're hearing this case. This is actually only the second time that I've argued before the Supreme Court in 25 years. I also know that these are important issues that we're addressing here that are beyond just this case itself, obviously, but not to lose sight of the fact that the primary reason that I'm arguing here is because Robert Kirksey, we believe, is entitled to a new jury trial due to an error that occurred with the charge, the jury charge. The reason that we're here is not only because you granted aliquot, but because of my office at 2 different times in the case preserved this matter. The first time was pre-trial. In accordance with Rule 103A1, we filed a motion in limine in which we sought, and we didn't seek to apply Mitchell because it had not yet been decided. We sought to apply Brady and preclude consent evidence from being put into the trial by filing this motion in limine. The second time that we preserved this matter was after the entire case had been heard. During the charging conference, we requested that the jury be charged with regard to that there was not an assumption of risk defense in the case because of evidence that was put in by the defense, both consent and the risk evidence that when combined, put in an implied assumption of the risk defense. In other words, our case was relatively straightforward and simple. Did this boy get double dosed or more for over 30 days? And the answer to that question was yes, at least double dosed and maybe even quadruple dosed, depending on what records you believe.
Counsel, Justice Baer, I must confess in preparing, I had some difficulty in understanding the parameters of your argument. And then you consistently therewith confused me a little bit in your statement. As I read the issue, as stated by you, upon which we granted, it was failure to provide a limiting instruction.
Yes, Sean.
And as I try to get ready and as I listen to you, you seem to conflate the question of a limiting instruction during the trial with a point for charge or a charge that should be given subsequent to the trial. You see no distinction between those two matters?
Well, Your Honor, yes. Well, number one is a jury charge can be broad. A jury charge itself can be broader than a limiting instruction. It can be, but a jury charge itself also is a limiting instruction when what you're doing is asking for a judge to define the parameters of the evidence. In other words, how is a jury, you're asking a judge to use a charge to assist the jury with how it is that the evidence that came in should be evaluated. So in other words, when a jury instruction could be considered broader than a limiting instruction, but what you see with the charge I proposed here, we did ask for a limit on the evidence in the manner that they were going to consider it.
Let me stop you for 1 second. So I think a fair summation of that answer is that you do view the point for charge as the equivalent of a limiting instruction. Let's just assume for discussion I accept that. The difficulty then is that, from what I can tell, you didn't submit any points for charge. There's none in the record.
Well, it is, Judge. It's at page 2733 of the record. Although I think what you're raising is an issue that the defense attempted to raise, claiming that this matter is not in the record. It is in the record, Your Honor.
Okay, 27 to 33, the reproduced record?
Yes, Your Honor.
Why don't you read for the court for a quick edification the charge that you requested and was denied?
Additional instructions requested were as follows. Plaintiff requests that the jury be charged/advised that assumption of the risk is not a defense in this case. And then under the word proposed, we also offered the following. You have heard conflicting testimony as to whether Dr. Godella advised Jerry Lynn Kirksey and Robert Kirksey of the risk of rash. It is for you to decide the credibility of such testimony. However, even though there is such a dispute in the testimony, even if you were to credit the testimony of Dr. Godella and not Mrs. Kirksey, there is no defense in this case of assumption of the risk.
Well, let's go back to the pleading. Assumption of the risk is an affirmative defense. It has to be pleaded or waived. Did the defense plead assumption of the risk?
They did not, Judge. In fact, they did. They argued at trial.
Well, then why would you want to charge that said assumption of risk is not a defense? It was never a defense.
Well, Judge, it was never, it should have never been in the defense in the case until it was made.
Well, it wasn't a defense. You just said they didn't plead it. It has to be pleaded or waived.
Your Honor, I agree that they didn't plead a defense. I agree with that statement. But what they did do is put evidence in that asserts an implied assumption of the risk defense into the case. Example, why is the page 43 of their own brief, why is there's no relevance to the conversation between Dr. Godella and Mrs. Kirksey, yet you have that conversation in the record. And so then you say to yourself, well, what is this case about? Well, what this case, they made the case about was no longer about double dosing, Your Honor. They made it about, they came to a fork in the road and they had a choice to make, a balancing of the risks and the harm. On the one hand, the risk of seizure, on the other hand, was the risk of rash. Which fork in the road do you want to take? And according to what you read from the judge at the beginning of the case, maybe this wasn't a consent case at page 645 of the record, but then right as we're in the charging conference, he says at page 1398, he, Robert, puts his faith in the mother and doctors. That's what they had turned the case into. They came to the fork in the road. The doctor referred to Mrs. Kirksey as his partner on his team and that they were engaged in teamwork. So as a matter of course, what they did was they turned it into this is an expert, very good, excellent medical malpractice defense attorney who knew how to turn it into this fork in the road case. So then I, in closing, attempt to address with a jury charge the fact that we've taken a case from double dosing and turned it now into they came to a fork in the road and mom was present in the car and she's making decisions.
One final question. We know the record. At the point in the trial where the testimony as to which you, at the close of testimony, sought an instruction. At that point in the trial, when the testimony came in, did you object?
We objected before.
Well, how can you possibly then request an instruction as to testimony to which you did not contemporaneously object?
Well, because
the testimony be stricken for the very reason you're now arguing you were entitled to an instruction.
Your Honor, may I address that?
Sure.
Your Honor, Rule 1, okay, so Your Honor, first, I think Rule 103A1, as a practical matter, it requires you to raise an issue one time. You either raise it by objection or by pretrial motion in limine. It does not say you have to raise it multiple times, and there's a reason for that, Your Honor. It's, first of all, the plaintiff bar already lives with the waiver guillotine hanging over its head. But the idea of Rule 103A1, one of the reasons you make a motion in limine and demand that this not be permitted at trial is because that way in front of a jury, you don't have to make the objection. It's outside the presence of a jury. Number two is the rule does not require multiple objections, I believe, Judge, because then otherwise we would never finish a trial. There would just be there'd be objection over and over. So I think that the purpose of the rule appears to be that once you've raised it, it's been preserved. And candidly, as a trial attorney, as a practical matter, Your Honor, if I try to raise that after I've already done it and been overruled, then in front of the jury, I just start losing even more ground.
Fair enough. Fair enough. Thank you.
Counsel, would you be nice enough, Justice Bear, one more time? Just tell me again. What did you raise? Great specificity, please. What did you raise in that motion to eliminate that preserves all this?
Your Honor, in our motion in limine, give me 1 second. We specifically argued the Brady case. We specifically argued that consent. If you give me a second, I'll find the exact page citation for the motion in limine. The motion in limine.
You can just tell me. We have the resources to go through the records.
Okay, page 526. Well, Judge, the motion in limine appears at pages 525 through 528, I believe it is. But on pages 526 and 527, we specifically in paragraphs 9 and 10 refer to the court's ruling in Brady versus Urbis, specifically cite the very language that ultimately the court itself, I believe, cites to in the Mitchell case and explains. So we cited to the exact language in Brady that this court ultimately addressed then again in Mitchell. And this is on page 526 and 527, but this is a 14 paragraph motion to eliminate, Your Honor.
Counsel, it's Justice Donahue. And I'm with you that you preserved your objection to any evidence being offered that the mother and plaintiff were advised of the risk and they took it on, otherwise consent. Okay, I'm with you on that. What I'm a little bit concerned about is how at the trial this evidence came in. Now, I know that you designed your case as a result of the ruling on the motion in limine. So let me see if I understand what happened here. In the opening statement, defense counsel tells the jury that the doctor is aware of this risk and he advises his patients of such. Okay, that's the first reference to it. You then put the mother on the stand and you ask her about whether or not she was told of this risk. Now, you designed your case based upon the motion in limine. There's 2 times that I know of specifically that this notion of advising of the patient of the risk comes into play. Where else in the record does either the defendant doctor testify as to such advice to the plaintiff, or you refer to records being put in that refer to advice to the patient? And let me tell you why I'm asking you these questions. I read the trial court's opinion, and he seems genuinely confused as to how this is an issue in the case. And I'm wondering if that's because the references were so few or innocuous that he just didn't see it. Because I can't find any other references to advice to the patient other than those that I've just discussed with you.
Your Honor, to address your question, Your Honor, just I want to come back to one of the amicus briefs because it's interesting how they pointed it out. What they say is that.
Would you answer my question?
Yes, Your Honor.
Did the
if
doctor
you look,
testify that he
yes.
by other of the?
If you look at pages,
Counsel, could you just stop? You were talking over Justice Donahue and I couldn't hear her question.
My question is, did the doctor testify that he advised the mother or the patient of the risk of taking this medication? Did he testify to that?
He testified, Your Honor, that he did not recall the actual appointment, and therefore his testimony was, I'm relying on the record itself, and he testifies to that at two different places, I believe 1232 and 1233. Then they used the record itself and put it on the screen. At pages 1241, it begins where he refers to mother as partner, and then on 1242, at the bottom of the page, over to 1243, is the record on the screen with the specific notation rash. This is also used with Dr. DeBasio. The note was used with Dr.
Pardon me, counsel, I'm sorry, I don't want to talk over you. What is the specific notation that you just
specific notation? 1232 is where the court could start, but if you look at pages 1242, 1241 through 1243, but at the bottom of page 1242, leading over to the top of page 1243, is where the note is on the screen, and the reference is basically, give me 1 second. This is after he's testified. Line 22 question. Now, it did indicate that you were aware of the risk of rash. Answer, yes. And we know that combinations of Lamictal and Depakote, we increase further with the chance of rash. That is the reason I reduced the Depakote and started the lamotrigine dose very low. This is at a point when the note itself is on the screen. It's been on the screen for about 15 minutes or so in the testimony, but this is the point where point number 4 is on the screen and they're talking about it specifically.
And counsel, I'm just gonna, just one more time and then I'll let this go. Does that note say advised patient of this risk or anything similar to that?
Yes, Your Honor, it says at page 1548 in the record, it says, at page 1549, I have discussed in detail about the side effects, including rash.
Okay, thank you.
Counsel, could I ask you a question? You may have responded to this in part, but I'm not sure I caught it. Can you point out to me where your points for charge are in the certified record? Because your reproduced record has copies that are not time stamped. So I'm trying to see if there's compliance here.
Yeah, Your Honor, I'll tell you exactly what I know about this currently is that it was not filed with a timestamp copy. So you're not going to find that. And the court is correct on that. And they're correct on that point. But it is in the reproduced record at page 2733, because when it's being put together for the Superior Court, apparently people noted that it wasn't present and it was put into the record. Then
that's not, the reproduced record is meaningless. I mean, that's just a convenience for us. If it's not in the certified record, why don't you have a waiver problem?
Well, Your Honor, I would have a waiver problem if they raised it. I think if they raised it before they arrived here with you. I mean, waiver, the first time they've ever raised this issue is with you in their brief to this
Are you
court.
saying we can't? Are you saying we can't raise that?
No, Your Honor, you're welcome. I think the court has wide latitude in what you are allowed to raise. And I also think that the court also has wide latitude in taking judicial admission of matters as well. You have a lot of power as a court. And I have great deference to that, Your Honor.
Counsel, how do we get around the rule of procedure that requires that either the point for charge be in the certified record or that it's read into the transcript at the charging conference?
Well, Your Honor, we did read, Your Honor, I can tell you that the entire charge itself wasn't read. For example, if you look at 2733, we asked for a charge about.
I've read it. I've
Okay.
read it. You didn't read
Here's
it.
the thing, Your Honor, I did read into the record that I requested an assumption of the risk charge, and that is at the record at.
I'm aware of that.
Okay.
We know that.
The
Counsel.
second thing I would say, Your Honor, is when I read Rule 103A1, well, first of all, it's not there. Mr. Kachoulis didn't raise it for a reason because he didn't want to get into the reason why it wasn't filed on purpose by someone who was terminated. So maybe the court should ask, I'm sorry, but I think the court should ask Mr. Kachoulis what his knowledge is about why the charge was not filed in the record. But number two is, I did read into the record the fact that we requested assumption of the risk. I would agree that the details of the charge aren't there, but Rule 103 allows a court to reach an issue where the context is clear. And so the case they've cited, I don't think has the proposition that they've cited it for. I think you can still, even if you took out the charge itself and said he did ask for assumption of the risk, it's right there in the record.
It's not a standard charge. I mean, you have the transcript of the conference, but there's conversation, there's mention of some standard charges, then there's discussion of other concepts. I mean, if I say assumption of the risk and somebody else says assumption of a risk in a conversation, we could mean different things. And so that you still got your preservation problem, it seems to me.
Your Honor, I think when you look at the conversation with the court, he shut it down right away. There was not even a discussion. I mean, I'm here. I had 2 charges proposed and actually a third. I had 3 charges proposed because Passarello charge was already being given, and I simply wanted there to be a balance to the charge so that the trial was fair. So if the court is if it's going to turn on that, then I don't know what I can tell you other than there'll be derivative litigation, perhaps, pertaining to the non-filing. I don't know what to say. It was not there. It was not there. It was not. I read it in the trial. If I went back in time, what I would do from this point forward is I would sit there and just read my entire point for charge into the.
You say you give them a piece of paper and hand it in and say, these are my points for charge. And typically the judge has already said, I accept point 1, I reject point 2. Point 3, I'll phase differently. That's how you do it. But we're not getting into the niceties of this. We're the Supreme Court. So if there's a waiver, we'll certainly discern it. And maybe counsel for the Aplt will speak to that issue since he raised it. So do you have anything else to add? We understand your position.
The last point I would make to that is that Justice Sweck, one of the reasons that waiver is argued at the first available point for if a party is going to argue it, so that the other side can address it before you get to this point. And, so why is it that when they moved to strike various portions of the Heddleston record, because I was trying to point to the court a pattern of behavior, they didn't move to strike it, and the Superior Court's decision was reliant upon that being part of the record. So that's my best argument I can offer on that.
Thank you. Mr. Kachoulis.
Yes, Your Honor. May it please the court, George Kachoulis on behalf of the defendants in this case. And at the outset, I would just like to state that this may be the first instance in appellate jurisprudence where an attorney is claiming reversible error for the failure of a trial court to give a jury instruction on a principle that he conceded was irrelevant, and that is assumption of the risk. when even the charge, and I'll get to it in a moment, is basically a statement, if one accepts it, and we believe there was waiver in this case, that the counsel was asking the court to state that assumption of the risk does not apply. And then is trying to turn that into the question, which I must stress with the court, because the very question upon which this court granted aliquotter involved the statement that this particular case was in conflict with Mitchell. That's inaccurate. I'll get to that in a moment. And two, that a limiting instruction was requested. That's inaccurate. One was never requested. And three, that the Superior Court glossed over that request or those circumstances. Again, that is also an inaccuracy and a mischaracterization, because what the Superior Court was confronted with was a number of issues raised by counsel, but this very one solely focused on that particular point for charge in the legal principle which counsel conceded didn't apply, which was assumption of the risk. And the trial court easily dismissed that. If one reads the transcript at the time that the charge conference took place, this does not apply, therefore I'm not going to give it. And it only logically follows that why would a court give a charge on a principle that everyone agrees doesn't apply to the case, and there was no evidence. Therefore, the basis upon which this appeal was granted, because this clearly is not a Mitchell case. Mitchell was dealing with a surgical setting and the issue of whether risks and complication evidence should be admitted. Again, distinguishing, this is a medication. This isn't a surgical procedure where the issues of informed consent even come into play. But secondly, everyone agreed from the outset of the case and during the discussion on the motion in limine, counsel expressly conceded everyone is going to talk about the risks, the complications, the side effects, including Stevens-Johnson syndrome. And what he was referring to is all of the medical doctors were going to talk about it. So the risk and complication evidence was inherent in the very claim.
Mr. Kirksey, Justice Bear, I don't think Mitchell is limited to the surgical sphere. I think the import of Mitchell, and I'm interested if you agree, is that while the majority of the court, and I was in it, held that risks and complications of medical procedure, including pharmaceutical dosage, are admissible to determine the standard of care. They're inadmissible for the proposition that the defendant consents to those attendant risks, on the grounds that those attendant risks may or may not be caused by a breach of that standard of care. Would you agree so far?
Absolutely, Your Honor.
Okay, so then let's translate that to this case. And again, as I said to your colleague, I'm having some problems getting it focused here. Whether mom, on her and child's behalf, were aware that a rash, terrible rash, scarring rash that causes a month in the hospital, could occur from the dosage provided, is not relevant to whether the standard of care was breached.
I would agree that if there was consent evidence, I would agree with Your Honor. If there's any evidence of consent, that should not be part of the case, and it clearly was not in this case.
Yeah, at least we're making progress here among lawyers. Then, apropos of what Justice Donahue asked, and it caught my attention also, it seemed to me that at least on a couple occasions during the case, the testimony was, and I confess, I don't know who raised it, how it was raised, but the testimony was the plaintiff was advised of the risk of rash. why is that not at least bothersome in terms of creating an inference that the plaintiff, mom, was accepting that risk?
Because it was clearly couched in terms of establishing a standard of care. Because in medication of this type, including the manufacturer's guidelines, which were part of plaintiff's case, the entire case, and plaintiff expert report and their complaint, there is the allegation that the failure to advise of the risk is negligent. What makes this different than the surgical case is when we're dealing with medications of this type, the standard of care clearly required it. And so when judge at the trial court level specifically limited the evidence and testimony to that one line in the doctor's note, and plaintiff then presented the evidence solely focused on the statement of the doctor, and then followed by his own expert's testimony that he would advise the patient of this rash. And if you accept the note, the doctor satisfied the standard of care. That's the last testimony in this case. There was no implication or inference of a consent process, but it was absolutely essential for the defense to establish that he met the standard of care, because when you're balancing risks associated with anti-epileptic medications of this type, when you are informing and the exchange of information between the patient and doctor is to ensure that the doctor is prescribing something appropriately, there was no consent component to this at any time, either by inference or direct evidence. It was steered clear of, and the trial court was vigilant of it, hence his limitation. And after he limited it, at no time did counsel request a limiting instruction. So when the evidence been through his mother, I'm sorry.
Let me just follow up on that. The clear implication of getting testimony in that the patient was advised and then the medication was given is that there was implicit consent to the medication being given. How does that go to a standard of care? And well, by the way, my understanding is that there was a failure to warn claim originally, but that was dropped prior to trial. So, I'm confused. I mean, I see implicit consent in any mention of the fact that a patient was advised and then the treatment is followed. There are other issues in this case, but that implicit consent to me is, part and parcel of getting into the evidence that I advised the patient. Oh, and by the way, then we gave the medication.
Your Honor, I think there is a difference, and I would submit to you there's a difference between implied consent in a vernacular or in common parlance and actual consent in a setting of medical care and treatment when you're talking about information and consent. That's a process that's a legal term and is a legal principle that to take your Honor's question one step further, then every form of treatment involves consent. It's always implied, whether it be in the form of prescribing any type of medication, even something as innocuous as ibuprofen, which, by the way, can cause Johnson syndrome.
This was advice about the rash. I mean, that's where the implication is. I agreed, knowing that there might be a rash. Why else would you get that? Why else would you want that in the record other than to have a jury to be able to make that leap?
Because, Your Honor, with the inability to put that into evidence, when, as I noted earlier, it was conceded from the outset that risk and complication evidence was the crux of plaintiff's entire claim, that everyone was going to talk about the risk and complication, whether it was idiosyncratic, meaning it could occur at any time, or allergic, which was what the defense was, and I thought we proved that easily, or whether it was due to double dosing, which was plaintiff's claim. So if the entire case is about risk and complication, if the jury does not hear that the doctor advised the patient or had an appreciation of that risk and then took it to the step to advise the patient, not for purposes of obtaining consent to treatment, but just to show his knowledge. And so when the trial court served as the gatekeeper in limiting it to that line, the focus remained on the doctor. And plaintiff's counsel did not drop the claim of negligence once the motion in limine was ruled upon, because he affirmed.
He had a failure to warn claim, which is what you referenced earlier.
Correct. Correct. Because when the first witness in the case then was Geraldine Kirksey, the mother, and he affirmatively asked her, did Dr. Gadela tell you of this risk? She said no. So now the defense is put into the position of defending the negligence for failing to warn. And when my partner who tried the case with me, Sally Frick, asked the question, did Dr. Gadela advise you? She again said no, and we stopped the questioning there. And then when his first witness in the case that was an expert, took the stand, he puts the note into evidence. They discussed the risks and complications, and my cross was very limited. It was, and he had it in his expert report, the duty to warn of the risk and what he does when he prescribes this medication. And it was in accordance with those manufacturer guidelines. And I crossed him on it and specifically said, this is standard of care. Now, when you look at the transcript that was put into evidence, there are a lot of objections of plaintiff's counsel, but he did not revisit those with the trial court.
Counsel, I'm sorry, it's Justice Barrett. I think Justice Donohue are on the same page. Why isn't your argument easy? Why isn't your argument based upon what you just told us, that they opened the door?
Yes.
I mean, and that at least would give, I'm not convinced, as I think Justice Donohue is convinced, that you can put into evidence in a med-mal case, not an informed consent case, that plaintiff was advised of the risk. That seems to me to go against the pretty nuanced distinction we made in Mitchell. I think you can say if plaintiff got on the witness stand and opened the door, that you can then drive a truck through it.
I would agree, Your Honor, but I just have to emphasize the one distinction with a medication as opposed to a surgery.
All right.
The standard of care, no, but if the standard of care includes the necessity of advising of that risk, which you would not have in a Pennsylvania surgery case, because we do not have a claim for negligent failure to advise of risks in Pennsylvania. Informed consent law, when we're dealing with Chenal and its progeny and even the predecessors in the statute, informed consent law, experts are not allowed to state, this is what I say, if the failure to do so was negligent. But in a medication case, they can. That's why this does not fall within the ambit of Mitchell, and that the trial court served as the gatekeeper and kept the evidence limited so that we had an opportunity to show that Dr. Gadela had the knowledge of the medication, communicated to that patient, and it was limited.
Before, I think we're close. I'm sorry.
I just want to follow up with your question, but I'll wait.
No, go ahead, Justice White.
Well, given what you've said to Justice Donohue and Justice Baer, there was all sorts of testimony about risks. In that particular circumstance, wasn't it most appropriate for the trial court to give an instruction to the jury that this evidence about risks is not evidence of consent to treatment that falls below the standard of care? Well, wouldn't that have been most appropriate?
Your Honor, I would agree to a degree. I think that would have been a good time for potentially a limiting instruction that this evidence is being admitted solely for the purposes of determining either the negligent or non-negligent conduct of the doctor, or if he met the standard of care. I would object to a degree if that was followed with, but not for purposes of informed consent, not for purposes of assumption of the risk, because then we get into the circumstance where we're introducing legal terminology, which will require detailed explanation, when thereafter the court will have to say, I just gave you a detailed explanation of assumption of the risk. That does not apply. I gave you a detailed explanation of a very complicated concept of informed consent. that does not apply. But I would agree with you, Your Honor, it would not have been a bad time for a limiting instruction, but counsel didn't request it. And all that was requested in this case is as Your Honor pointed out, was that charge, which one was not made part of the certified record, two wasn't read into the record, and three has no bearing on the issue we're talking about. It doesn't deal with consent. It doesn't deal with negligence. It makes an argument, and it even mischaracterizes the evidence and says assumption of the risk does not apply. That provides no guidance to the jury. So even if the court assumes that that was properly filed or certified, which it was not, and it wasn't read into the record, it does not address the issue which all of the justices today have been discussing.
Counsel,
Can I
Justice,
follow up with Justice Wecht for 1 second? You're using the phrase limiting instruction, and indeed our grant of aliquotter, which was phrased by the defendant, by the plaintiff's counsel, uses that phrase. But that's lifted from Sikora, and I'm not convinced that you can get either or both a limiting instruction and a point for charge. I don't think that there was precision attached to the phrase limiting instruction in Sikora. Do you think there is? Do you think it makes a difference?
You mean in the Sikora case, limiting instruction?
In any case, if a judge is going to instruct a jury as to how evidence can be used, what's the difference if it's done at the time the question and answer are given or in the points for charge?
There's not a drastic difference, Your Honor. I think that for clarity purposes and practically speaking for the jury's understanding, it may be better when it's timely done when the evidence comes in, if there needs to be a limitation placed on that. It can be addressed in some respects in a point for charge, but that's where you're giving the law to the jury to apply. And you may include that in a charge, but that was not done here. This was a negative. Assumption of the risk does not apply.
We understand that. We've heard it many times.
Okay.
Okay, Justice Beer, did you have a question?
Chief Justice, the only thing I was going to ask, because we've engaged in a very interesting legal discussion, which I frankly enjoyed. Can you tell me, and with the Chief Justice's admonition, your time is up, just in a sentence or two, simply and directly, why there's waiver here? Why we should IG this case because the plaintiff hasn't preserved their issue?
Because one, there was no limiting instruction requested when the evidence came in after the court ruled, and two, the point for charge upon which aliquotter was granted was not properly certified, was not read into the record, and really doesn't deal with the subject matter which is being discussed today or that issue regarding the statement which was made to the mother. It doesn't address that at all.
Well said and helpful. Thank you, Chief.
Any other questions? Thanks to both of you. We'll take a brief pause while we bring counsel for the next case online.
The next matter is the Commonwealth of Pennsylvania versus Waylon Marie Howard. Representing Ms. Howard is Ms. Jamie Schuman. Representing the Commonwealth is Mr. Kevin McCarthy.
Good afternoon. This criminal case involves the charge of endangering the welfare of a child. The defendant purchased a rideshare service for herself and her 3-year-old daughter. The rideshare driver did not provide a car seat, and the mother failed to strap the child in with a seatbelt. The question before the court is whether the defendant's failure to buckle her child with a seatbelt was criminal conduct sufficient to support the endangering charge. Ms. Schuman?
Thank you. May it please the court, I'm Jamie Schuman on behalf of Ms. Howard. Ms. Howard made a parental judgment call that doesn't rise to the level of EWOC. Pennsylvania courts have upheld EWOC convictions for acts of sexual and physical abuse, failure to report such abuse, failure to seek medical care when a child is at imminent risk of death, or other extreme acts or grave omissions. Behavior in those published cases clearly met the mens rea of knowingly and offended the common sense of the community. Ms. Howard's behavior did not. There is insufficient evidence under any of the tests that courts have used to define the mens rea for EWOC, but I respectfully ask this court to clarify that standard to the extent that there is confusion. The mens rea applies to the element endangering the welfare of a child, which involves the result of one's conduct, and to the element by violating a duty of care, protection, and support, which involves the nature of one's conduct. Applying Section 302(b)(2), EWOC requires one to be aware that he is violating a duty of care and aware that it is practically certain that his conduct will result in endangering the welfare of a child. Ms. Howard's actions did not meet this standard or the three-pronged test that the Superior Court has used. Ms. Howard didn't knowingly endanger her daughter's welfare. The chances of an accident are relatively remote when one gets into a car. There was no evidence that the driver was driving unsafely. Moreover, it's unrealistic and impractical for parents to haul car seats at all times when they don't have their own car, and the Commonwealth seemingly concedes this point in its brief. There's little legal guidance about how parents should handle children's ridership and ride shares, and experts warn that it is dangerous for young children to wear seatbelts without booster seats. Additionally, the behavior at issue is merely a summary for drivers under the Motor Vehicle Code. I respectfully ask your honors to vacate Ms. Howard's conviction.
This is Justice Mundy. I have a question. I can understand your argument with regard to the burdensomeness to some extent with regard to dragging a car seat when in fact you don't own a car. But I don't understand why the contemplation wasn't to at least sit in the back seat with the child and have her restrained, because in fact, this result, even though maybe a car accident per se may not have been anticipated, but cars stop quickly, and to have a child loose in a back seat is concerning under this argument.
Yes, Your Honor. Well, this was a stipulated non-jury trial, so we don't know the backstory. But it is important that this is a rideshare and the driver was a stranger. So perhaps, it was a logical decision for Ms. Howard to want to sit in the front seat to supervise the driver to ensure that they're going to going to the correct place. I think that, my point is that this was really that Ms. Howard, was making a judgment call, and the EWOC statute wasn't meant to punish that.
Justice Fair, and just in follow-up, Justice Mundy and I think had the same thought. This is more than just a car seat case. Mm-hmm. Your client did not. We know this car had a seatbelt. We can take judicial notice that every car in the United States since 1967, and I'm old enough to remember cars without them, 67 has had a seatbelt. And I understand the expert testimony, but she didn't say, I better not put a seatbelt on this child. The seatbelt might hurt this child. So prudence would be that she'd put a seatbelt on the child. Prudence would be that she'd sit in the back seat with the child on her lap and a seatbelt over both of them. She'd sit in the front seat because she wanted a harness, if you will, with the seatbelt over them. At the very least, she would put the child cat-a-corner to herself behind the driver, so she had some chance to get a hand back there in case something happened to hold the child in. So, as I say, it's got all these possibilities. The inference from this record is almost a total concern, lack of concern with the welfare of her child, or any child, by putting her behind her rather than juxtaposed to her, not using a seatbelt, not doing anything to protect her.
Yes, Your Honor. I mean,
why is that not? Well, you know, and yeah, I think you understand my point. Why isn't that? Not because of the lack of a car seat. I keep saying that, but on a totality of the circumstances, EWOC.
Sure. Yes, Your Honor. Well, first, oftentimes when you get into a ride share, it's rushed. It's a rushed entrance. Second, it's important that it's dangerous for a 3-year-old to be in a seatbelt without a booster seat. Under the Motor Vehicle Code, a child who is under 8 needs to be, if they're in a seatbelt, they need to be in a booster seat. And the reason is that someone who's as young as 3 would be too small and it could hurt them. So I think that is a logical judgment call to not put them into a seatbelt. But I also think,
Counsel, this is Justice Doherty. With all due respect, you're asking us to find that it's logical for a mother to place her 3-year-old in the back seat of a foreign vehicle and not place the child in a seatbelt because it could hurt the child, yet knowingly leave the child unassisted alone without that. And you're telling us that that is logical when the law asks if the person knowingly endangered the welfare of the child. Share with me, how is that not knowingly endangering a child based upon your logical explanation?
well, Your Honor, it's not knowingly endangering a child because one doesn't expect to get into an accident when they get into a car ride, when they ride in a car. And the Superior Court has found in the Mastro Mateo case and the Bullock case that accidents are in fact uncommon in car rides. And here there was no indicia of unsafe driving. Perhaps it would have been different if Ms. Howard knew getting into the vehicle that the driver was intoxicated or speeding. I think then maybe she would have had, it would have been a better case for EWOC. I think also here it's important that this was a rideshare situation, which is, a unique situation where the laws and the standards are not clear on what to do.
But counsel, the law is very clear as to violating a duty of care only. This is not with regard to the driving capabilities of the driver. It is knowingly endangering an individual as part of a parent's duty of care. I find your argument extremely weak, and I'm trying to understand your logical. It seems as if you're just reaching for straws. I still don't understand how any reasonable person would allow a child to be seated alone and they would sit up in a front seat, passenger seat, with an unknown person, when we do know statistically that women usually are offended by male drivers. There's a litany of cases for that. Why would a woman, in even taking care of herself, engage in such reckless conduct? I'm shocked at your argument. So I'm trying to find some plausibility in it. Help me.
Yes, Your Honor. Again, EWOC requires one to knowingly endanger the welfare of a child. And my argument is just that, in a one-off car ride, when there is no speeding or indicia of unsafe driving, that she wasn't endangering the welfare of her child. She was just making a decision, making a judgment call, and trying to get home.
Thank you.
Could I follow up, counsel, briefly? You focus on the lack of knowing endangerment, making reference to the infrequency of accidents and the like. Would you comment on whether the law ought to allow the Commonwealth, in effect, to reason backward retrospectively from the consequences of an unanticipated accident to focus on to address the knowing endangerment question? In other words, is it appropriate under the statute for the validity of the knowing endangerment question to be assessed retrospectively from the consequences of an unanticipated accident?
I don't think. Yes, Your Honor. I don't think you can analyze it retroactively or retrospectively, because you're looking at what she knew getting into the car.
The same tenor. Although this is framed as a sufficiency challenge, to me it seems really to be the legal standard for endangering the welfare of a child. And in addition to this concept of knowing endangerment, I think the mens rea of knowingly varies for conduct and result. For a conduct element, the actor is aware that his conduct is of that nature. But for the result element, and this is from the statute, he is practically certain that his conduct will cause such a result. Doesn't this really turn on the mens rea of crime, perhaps coupled with the role of lenity when you're construing criminal statute?
Yes, Your Honor. I do think that it's important to apply the statutory definition of knowingly under Section 302. And under that, EWOC would require one to be aware that he's violating a duty of care and aware that it is practically certain that his conduct will result in endangering the welfare of a child. And my position is that standard isn't met. My position is also that the standard under the three-pronged test that the Superior Court has used, it also isn't met. And the Superior Court's test is limited by the actions need to offend the common sense of the community. And if you look at the published decisions, these cases of severe physical abuse or sexual abuse, I think in those cases the harm or the risk of the harm was clear, and that people would uniformly decide that was endangering the welfare of a child. But I think this is a different case. This was a judgment call. And I do think that people's opinions on what to do in this type of situation will vary depending on where they're from, whether they're from an urban or rural or suburban area, their socioeconomic class, whether they own a car, whether they rely on public transit, where at least in Pittsburgh there are no seatbelts on buses, their age. And again, I think that this was significant, that this was a rideshare situation, that people take ride shares oftentimes when they're in a jam, and people view them sometimes as different from a personal car ride. And the laws and standards regarding ride shares are unclear, and just the fact that there's that lack of clarity makes it, one, that it doesn't offend the common sense of the community, and two, the knowingly standard isn't met.
Ms. Schuman, it's Justice Todd. Could you compare and contrast the legal consequences of this mother's actions if she did this same act, place the child in the back seat without a seat belt or a booster seat, and was also the driver of the car? How would the case differ?
Exactly, Your Honor. If she was a driver, then she would be liable under the motor vehicle code for a summary offense, and that summary would be dismissed upon showing that she obtained a car seat. So the motor vehicle code seems to take more of an educational approach to this, and I think it's a very big leap to go from that where, in a situation where she's the passenger, that she is then liable under the crime code for for a crime that could have significant time and have collateral consequences such as effects on custody.
Well, at first blush, that seems to be a very important distinction, but wouldn't it be the case that if you were the driver, in addition to being charged with the summary offense under the Motor Vehicle Code, she could also be charged with recklessly or knowingly endangering under the Criminal Code?
I'm not, Your Honor, arguing that she couldn't be charged, under both the Motor Vehicle Code and the Crimes Code, but as the dissent stated below, I think that result would be exceedingly harsh. It might not be uniformly done, and also while she could be charged, again, I think that under the facts of this case, that there isn't enough for a conviction. And again, there's a kind of a big jump between the Motor Vehicle Code and the Crimes Code, and I'd point to some of Judge Kavanaugh's the concurrence that I cited in my brief from Ogun, where he stated that some type of behavior perhaps aren't best suited for parental conduct, isn't best suited for the Crimes Code. Perhaps there's other types of solutions.
Well, it does seem to be a notable contrast when, if the driver is just given a slap on the hand under the Motor Vehicle Code and told go buy a car seat, and the passenger who does the same thing is criminally charged, it does raise concerns.
Exactly, Your Honor, and I think there's a hole in the Motor Vehicle Code. Under the Motor Vehicle Code, ride shares are dealt with in exactly, they're treated as passenger cars, but also, as we were discussing, under the Motor Vehicle Code, it's if it's the driver's responsibility, and the driver will get a citation if a passenger doesn't have an age-appropriate restraint system. But in these ride-share situations, chances are it's not the parent who's the driver; a stranger is the driver. Whereas in a personal vehicle, it's the parent who's the driver. So,
I understand.
Perhaps.
Yeah, thank you. We have the drift of your argument, and unless there are any other questions, we'll hear from the Commonwealth.
Thank you.
Thank you. McCarthy.
May it please the court, Mr. Chief Justice, members of the court, Kevin McCarthy for the Commonwealth. Your Honors, if I could cut to the chase for a moment. This case is a one-off. Because of section 4581 of the Vehicle Code, introduction of failure to use a restraint system cannot be used for any purpose in a criminal case. It can only be used for prosecution of that Vehicle Code offense. This case, for reasons beyond me, no one caught that. Not the trial attorney, not the trial prosecutor, not the trial court. And so there was a stipulation regarding this defendant's failure to use a restraint system on her child. And that's why we're here today. This case is carried through to this day. It's probably incapable of repetition for that reason, because it will always be objected to. And regardless how this court should rule, even if you should agree with the Commonwealth that the evidence is sufficient for purposes of endangering the welfare of a child charge, this conviction is going to be reversed as soon as it gets remitted back to the trial court and there's an opportunity to file a PCRA petition raising counsel's ineffectiveness for that very point. So this is going to go away, whether you do it today or when you decide this case, or whether it goes back. I should also note that you could find, as a matter of law.
Mr. McCarthy?
Yes, sir.
Justice Baer. And I said to your opposing counsel that I see this case far more than just the car seat. It's depending upon how it's written. There's a determination that the car seat was not determinative credit with failure to use a seatbelt, failure to put the child on your lap on the front seat, failure to sit in the back seat, failure to have the child juxtaposed to you, front seat, and then the child being on the rear side. Couldn't the passenger rear side, I'm sorry, the driver rear side. Isn't it possible that as PCRA goes, that the putting into evidence of the failure to use the car seat is harmless error?
I think failure to use a car seat versus a seatbelt are both restraint systems described in different sections of 4581 of the Vehicle Code. I wouldn't say it's harmless error. It's the fact that a mother, certainly a person with a duty of care to the child, failed to make or take any steps to protect the safety of that child. As mentioned previously in the argument, she could have used the seatbelt in lieu of what she was faced with. All she had available to her was a seatbelt. And as I said in my brief, if she had only done that, she would not have been charged.
And I think that's right, and she may not have been convicted. Conversely, if she had tied the child to the roof, you'd have better facts.
Much, yes, Your Honor.
So, Mr. McCarthy, what was your first point? I missed that. You're saying this is going to be reversed on collateral review?
Yes, Your Honor. Title 75, Section 4581F. The legislature has mandated that the introduction of failure to use a restraint system cannot be introduced into a criminal case except for a violation of that section. For that reason, this woman probably should not have been convicted on these facts. But
if that's a concession on the part of the Commonwealth, that seems to be, we would have appreciated you raising that pre-argument, and instead of, and I appreciate your candor, but a good time to advise the court of these things is when you're briefing these cases, because our resources.
It's in the papers.
Is it in here? I can't find it.
Appellant has it at page 41 of their brief.
I'm talking about the Commonwealth's brief.
Your Honor, I did note the fact that counsel had raised it, but it was waived for purposes of this case because it was never raised. I'm now bringing it to the court's attention because I believe counsel has brought a valid consideration before the court as to the knowledge requirement, the mens rea for the endangering the welfare of a child. That is an issue that the court wanted to hear, and therefore I thought it was appropriate.
I appreciate that. No problem. And I don't want to interrupt your argument, but if the conviction is affirmed, you say it'll be reversed on collateral review. If it's reversed now on the state of this record, then she'll be discharged in any event. Thank you.
Yes, Your Honor.
Since we're all dressed up here and ready to go, I do want to ask you about the mens rea. So along the lines I inquired of Ms. Schumann, I'm interested in the mens rea because it seems to me as a practical matter, these things are always going to be assessed in retrospect. In other words, the charging decision by the Commonwealth on an EWOC, whether it's, putting the seatbelt quirk of this aside for a moment, in any EWOC situation, the charging authority is always going to be looking at the gravity of what happened in practical terms. But I think that's a dangerous thing because, again, and I think the principal issue on review here is the mens rea, the knowing endangerment. Don't we have to assess culpability by reference to this mother's state of mind at the time of the alleged endangerment and not simply resort to the unfortunate eventuality that did occur? Do you follow my question?
I do, Your Honor. I do. And respectfully, this is a question, this case involves the sufficiency of the evidence. And we have here included in the record a stipulated statement from the mother, corrected through the stipulation, I should say, that she told the officer at the time he was investigating the accident that she thought the child would have come over the
So you do agree, just one follow-up briefly, you do agree that there had to be a determination as of the time of the alleged conduct, in advance of the accident, that there was a substantial risk of harm. In other words, not parental conduct that poses any risk of harm, right? Because that's a slippery slope. That there's any kind of parental conduct could cause any kind of harm any day of the week, right? It has to be substantial risk of harm.
I don't know if I agree with that, Your Honor. The statute is that there's a violation of a duty of care, and if you're asking or focusing on that as being what must be substantial, I suppose I agree with you. I certainly don't agree with counsel's argument that Section 302 B2 sub 2, that the counsel or the defendant must be practically certain of the result of the conduct is correct. I believe those are two independent clauses, though joined with an and I noted this in my brief, they're really independent clauses. And that's been noted several times in several of the Superior Court decisions, most notably Cartwell by Judge Beck, and it's been noted several other times. So if that answers your question.
Counsel, this is Justice Donahue, and this is in follow-up. I understood Justice Weck's question, and I don't think your answer at least answered it to my satisfaction. What does 302B2 II mean if it doesn't mean what it says? She is aware that it is practically certain that her conduct will cause such a result. I mean, the concept of risk itself doesn't encompass that terminology. Practically certain means that she had to know at the time the child was put in that back seat unrestrained that this result was practically certain to happen.
Well, there's a condition precedent to that, Your Honor, and that is the first part of the clause. If the element involves a result of his conduct, as opposed to sub 1, if the element involves the nature of the conduct.
Right.
This is an offense that deals with the nature of the conduct and not the result. It is the endangering the welfare of child, not causing injury to the child. An aggravated assault using a deadly weapon is one which involves the danger, the actual result of one's conduct.
So whereas the conjunctive use, what does and mean? It's a dual requirement, is it not?
I disagree that it is, Your Honor, and the legislature did use and. But as you read the whole statute, subsection B or section B, 1 and 2, if the element involves, then this, and if the element involves, then that. If A, then this. If B, then that. They're independent clauses. They're not conjunctive, despite the use of the and. I understand that the legislature used and I understand that ordinarily that is a conjunctive and both must be satisfied. But under this construction, the way the legislature did it, they stand as independent concepts.
So counsel,
I'm
ahead,
sorry.
Justice Baer.
No, you go ahead, Justice Hockney, please.
I was just going to say, so if I'm following your understanding in lieu of Justice Donohue's question, the fact would be that since the mother is not driving the car, but is placing her child in a vehicle without the proper seating material, that for purposes of 302B2 small 2, it'd be practically certain that should that car get in an accident, that child would get hurt unrestrained. Is that your argument? Not that
No.
it's practically certain that the car is going to get in an accident because obviously the mother's not driving. So are you saying it's practically, are you saying that it's practically certain that the child will be injured should the driver get into an accident? That's the conduct that would result, and it would be practically certain the child would be injured. Is that what you're arguing?
That is not my argument at all, Your Honor. My argument is that subsection 2 does not apply at all because this is an offense, endangering the welfare of child, that deals with the nature of the attendant circumstances, not the result of conduct.
But counsel, if I just can follow up, I'm looking at the language of the EWOC statute. If she knowingly endangers, how do you disconnect the endangerment from the knowingly in that context? Does that not indeed go to the practically certain that this consequence will result?
No, Your Honor. I'm arguing that she must be knowing and aware that she is creating a danger to her child by not restraining the child.
Any danger?
Yes, because it's not any danger. It's to one which she has a duty of care. And the duty in this situation comes from the vehicle code to restrain a child of tender years in the vehicle. And that is what she violated.
Putting 4581 aside, Mr. McCarthy, putting 4581 aside, pretend it's not there for a moment, then the only difference is the underlying discrepancy here is that charging decision is made entirely based on what happens later when we're not supposed to be measuring knowing endangerment. Because if she's stopped by a police officer, no accident, she's stopped by a police officer, she's driving, and he notices the child has, no belt, he's going to cite her under the seat belt, under the vehicle code. He's not going to charge her with an EWOC. He's doing that only after something horrible has occurred. So my point is, don't we have this disconnect here on when the point in time at which we are assessing the knowing endangerment? And is that a problem, at least some level of a serious discrepancy of how we're measuring these things?
Your Honor, if the mother is driving and she's stopped for whatever reason, the officer observes the child unrestrained and he cites her for failing, he could also charge her with the endangering the welfare of a child. Both are present at that moment, is my argument. This touches on what Justice Todd had asked earlier. And I wanted to wave my hand and scream out the answer, Justice, that if it's a driver other than the mother, then unless it's the father, they're unlikely to have a duty of care to the child, so we could not establish an endangering welfare charge. Because the mother, in your example, Justice Wecht, is the mother, there is the duty of care. And so the violation, the failure to restrain the child in any way would be both. Now, let's assume for a moment that the mother had the child in the back seat, restrained with the seatbelt, but not an appropriate car seat. Then there would be no endangering welfare of child. It would only be violation of the proper restraint under the vehicle code.
Counsel, Justice Baer, I have two questions. The first is this a slippery slope? I appreciate that your office and the DA, who's a fine man and a reasonable man, has wide discretion in charging, and this is a one-up. But somewhere right now in Allegheny County, a mom sends a child to play out on the street without a mask. is that endangering the welfare of children. Sends a different child out a year from now without a helmet to ride a bike, to play street hockey or something. It can be charged. The violation of the duty of care, all that really means is you're a parent. That gives you the duty of care. And knowingly endangers, I mean, one can certainly argue sending a child without a mask today is inherently dangerous. So are we in danger of, if we affirm, which obviously is your job to argue for, of loosing on society the overly assertive DA in these cases?
I certainly appreciate your concern, Justice Baer. I too feel that we should not be into that kind of paternalism in our state. But the distinction here between those examples and failure to use a seatbelt is there has been a legislative determination that seatbelts are required. And so there is a recognition, a societal recognition as to what is a duty of a parent or one who has the child in their guardianship. And that would be my way of divining.
It's probably a good answer. And my last question is, from where you started, it's been a very interesting discussion, and we like this stuff, so it's not a burden to us. But is there any constraint on your office withdrawing this prosecution, even at this late date, in light of your recognition of the difficulty of your position on PCRA?
Well, we can't withdraw it. If it were to go back on a new trial, we certainly probably would withdraw because we can't go forward with the case. But there is on the books a conviction, so it's not for me to discontinue an appeal. And even if it did, that leaves it on the books. So it's, as they say, in your court, Your Honor.
And we've had this with the Philly DA in capital cases. You're between a rock and a hard place. Thank you so much.
Thank you. Thanks to both
Welcome.
counsel.
Thank you, Your Honors.
We'll take a brief moment to line up counsel for the next case.
The next matter is the Commonwealth of Pennsylvania versus DeWitt Johnson. Representing Mr. Johnson is Mr. Victor Rausch. Representing the Commonwealth is Mr. Dan Kasula.
Good afternoon. Before the Philadelphia Municipal Court traffic debate, the appellant, a criminal defendant, was tried and convicted of one of the three offenses that arose from a single criminal episode. The appellant asserted that his other two offenses were barred from prosecution by the compulsory joinder statute, which prescribes when a current prosecution is precluded due to a former prosecution for a different offense. On appeal, the Superior Court found that while all three of the appellant's charges arose from conduct within the Philadelphia Judicial, one of the appellant's offenses, possession with intent to deliver, was not barred from prosecution, since the maximum possible sentence exceeded the jurisdictional limitations of the municipal court. Presently, the appellant contends that the Superior Court's interpretation of the compulsory joinder statute is improper, and that therefore he is entitled to dismissal of all of his charges. Mr. Rausch.
Thank you, Your Honor, and may it please the court, Victor Rausch on behalf of DeWitt Johnson. Good afternoon. And just to clarify, Your Honor, I'm not contesting the Superior Court's interpretation of Section 110, but rather Section 112, which provides exceptions to Section 110's bar on subsequent prosecutions. I'm arguing that Section 112 does not apply. I think everyone agreed in Superior Court, and I think here, that Section 110 does cover this case. It's just that the Commonwealth and Superior Court felt that Section 112 provided an exception. And, Your Honors, I think this is a relatively simple, straightforward case of statutory interpretation.
Well, we've had a lot of those, and they never seem to turn out that way.
When Section 112 is properly construed using the standard tools of construction, it becomes clear that the Superior Court erred, and specifically they misconstrued when Section 112, subsection 1 talks about an offense, what offense they're referring to. The purposes of the compulsory joinders and protection versus subsequent prosecution statutes, sections 109 through 112, are, as this court has held, one of the main purposes is to protect criminal defendants from having to face multiple trials for a single incident. And looked at properly, the purpose of Section 112 is to make sure that an invalid prosecution can't be used to block a later valid prosecution. And I think that interpretation of Section 112 best comports with the entire statutory scheme, as well as the language of Section 112 in particular. It best comports with the title of Section 112, which this court is supposed to use when determining meaning. The title of Section 112 is, quote, former prosecution before court lacking jurisdiction or when fraudulently procured by the defendant. The whole thing refers to the former prosecution. And whether it's fraudulent or whether, in this case, there was a lack of jurisdiction, it would make no sense for that wording to apply to whether or not the former court had jurisdiction over the later offense. It's all talking about the former prosecution in the first court. The same is true with the language of subsection 1, which is the one that arguably applies in this case, the one that the Superior Court held applied. Subsection 1 says that a former prosecution will not bar a subsequent one when, quote, the former prosecution was before a court which lacked jurisdiction over the defendant or the offense. It would be very strange, that would be a very strange wording if that was meant to, if they were meaning to say that the former court did not have jurisdiction over the later offense. It makes far more sense to read offense in that sentence to refer to the offense actually in the former prosecution before the first court. That also makes a lot more sense with the rest of Section 112, all of which deal with circumstances where the first prosecution was invalid and thus shouldn't bar the second. Subsection 2 of Section 112 is when the first prosecution was procured fraudulently or through some sort of other illicit means. If that happens, which did not happen here, obviously, that should not bar a subsequent prosecution. Subsection 3 is for when the first prosecution is rendered invalid by a later habeas corpus or error coram nobis proceeding. Doesn't apply here, but they both deal with circumstances where the first prosecution was in some way invalid. And all of 112 should be interpreted that way. That makes the most sense with the language, it makes the most sense with the title, and it makes the most sense with the specific wording of subsection 1. That also comports with the rule of lenity. As your honors well know, this being a criminal statute, it has to be interpreted according to the rule of lenity, which means that it has to be interpreted as strictly as the language permits, not going against the language, but as strictly as the language permits, and any benefit has to be given, and the benefit of any doubt goes to the criminal defendant. In this case here, that would mean that it has to be the part of section 112 that allows later prosecutions has to be construed narrowly, which is exactly what I'm urging this court to do. And finally, this construction of subsection 1 of section 112 and of all of section 112 fits best within the entire scheme of sections 109 through 112. As I said before, section 112 read properly says no matter what else, no matter what the rules are that are set out in sections 109 through 111, an invalid prosecution cannot block a later valid one. That can be applied the same way to section 109, section 110, and section 111, which all bar subsequent prosecutions for all different circumstances. This also it's also important to keep in mind that all 4 of these statutes were passed at the same time in 1972, but the section 110 was later amended. None of the rest were. This is important because under the original version of section 110, I would lose. Because originally section 110 did not apply and did not bar later prosecutions unless all the charges were in the jurisdiction of a single court. But as this court knows, the legislature amended that language because it proved unworkable in 2002. That's important here because under the Commonwealth and the Superior Court's interpretation of section 112, it would be superfluous because section 110 would already not apply under those circumstances. And section 112 subsection 1 will be completely superfluous under the Commonwealth's interpretation here. And I don't think this court should read section 112 in a way that would have rendered it superfluous for the first 30 some years of its existence. For all of those reasons, I think the best reading of all of section 112 is to interpret it as making sure that an invalid prosecution cannot bar a later valid one. And thus, when subsection 1, which is at issue here, talks about a former prosecution being before a court which lacked jurisdiction over the defendant or the offense, they mean the offense that was before that court. This is a situation that happens. It happened in Schmatzer, the Superior Court case that I've cited and discussed extensively in my brief. And it happened in other times. That is a thing that just does occur at court. Sometimes a trial goes forward and it turns out later on the court did not have jurisdiction over it. That is what section 112 is meant to address. Unless the court has any questions.
Thank you, Mr. Roush. We'll hear from the Commonwealth.
Excuse me, Chief, can I ask just one question to clarify Mr. Roush's position? Do I have this right, Mr. Roush, that it's your position that in order to qualify under section 112.1, that the offense must have actually been litigated in the court that lacked the jurisdiction?
Yes, Your Honor, that's exactly my position, and that's exactly what happened in the Schmatzer case. It gives a good example of that.
All right. Thank you.
Chief Justice, it's Justice Fair. Counsel, isn't this about, and haven't we written, I'm a little fuzzy on this, that this is about double jeopardy concerns to these sections so that there can't be successive prosecutions?
Your Honor, all of this did arise out of this court's companion jurisprudence, which does, yes, address double jeopardy concerns. However, I'm only making an argument based on the statutory language. As this court has recognized, the language of these statutes goes beyond what this court required in Campana. This court specifically held in Hewed from 1983, I think, that the language in these statutes does go beyond what Campana requires, and that's fine. The legislature was free to do that and did so. So although the logic of all of these does originally come from double jeopardy protections, it goes a little bit beyond them. And that's why I'm arguing only based on the statutory language itself.
And I understand that, but you understand, obviously, that this defendant has never been put in jeopardy regarding the heroin and possession with intent to deliver heroin charges. And therefore, to the extent this is double jeopardy, notwithstanding your very clever argument on plain language, the underlying purpose of the legislation doesn't seem to be completely consonant with double jeopardy anyway.
And if I may respond, Your Honor,
Please.
It's not so much about double jeopardy as about, because again, Campana even goes a bit beyond at least the federal court's notion of double jeopardy. It's about the fact that a defendant should not have to face multiple trials for one thing that happened. This was one traffic stop. It probably took 10 minutes, I'm guessing. I don't know. But I can't imagine it took longer than that. Why should he have to face 2 criminal trials for that? That's what Campana was about, even though the federal Constitution's double jeopardy protections do not compel joinder, which is the whole reason why Campana had to go up to the U.S. State Supreme Court and come back here and all of that we don't need to go further into, but this does go beyond just double jeopardy concerns.
My only final query is, and it may be that the legislature has to straighten this out. We do see a fair number of cases where that's so. We saw that today already. But the Pennsylvania legislature did not intend that your client can run down to municipal court and pay a fine for whatever the underlying charge was, DUI, and then turn around and say, you can't prosecute me for my possession with intent to heroin. In a giant jurisdiction like Philadelphia, where it's very difficult for them to keep track of these cases. And if you read offense to apply to the second offense, that doesn't happen, which is where the Commonwealth's going to argue. So in terms of legislative intent, I think it's abundantly clear. Even if they wrote it wrong and they're stuck with it, it's not what they intended. How would you respond to that?
Your Honor, again, I would go back to what I said earlier about Section 110 and Section 112. Originally, that's why they wrote Section 110 the way they did. And so I would have lost under that. I don't think, but Section 110 was amended, and without going into all the long and tortured history there with McPhail and Fithian and everything and all of those cases, the original wording of Section 110 had other problems, and so the legislature revisited it. I don't think the legislature intended Section 112 to cover this case, because that just doesn't fit with the way it's written. And the way they did intend for 110 to shut me out before 2002, but that didn't work for other reasons, and they rewrote it. And frankly, that's their problem.
Fair enough. Thank you.
Well, Mr. Casella.
Good afternoon, Chief Justice, and may it please the court. My name is Dan Casulo, arguing on behalf of the Commonwealth. So listening to Mr. Roush's argument, it's kind of funny that I have almost the exact same points, but arguing the exact opposite conclusion. When you're looking at these words, the offense in Section 112, Section 112 is an exception to compulsory joinder. It's the whole context of Section 112 is that it's predicated on the fact that there is a subsequent prosecution that could be barred by Sections 109, 110, or 111. So it makes sense to interpret the words the offense in that same context, and that the offense refers to the offense that is the subject of the otherwise barred prosecution, the prosecution that Section 112 is contemplating and potentially providing an exception for. Mr. Roush mentioned that the Commonwealth's interpretation would nullify Section 112, but if you think about it, it's Mr. Roush's position that would effectively nullify Section 112. According to the defense, Section 112 would only apply in a situation where the former court lacked jurisdiction over the former offense. And when you think about that scenario, that would be a court making an adjudication without jurisdiction. There's no valid judgment or conviction there. Sections 109, 110, and 111 all require there to be a conviction or acquittal in order to bar a subsequent offense. So basically, the only situation where defendant's interpretation of 112 could apply is a situation where you don't even get to section 112 because sections 109, 110, and 111 don't apply. And that's exactly what happened in Schmoetzer. In Schmoetzer, there was a federal case, and then later it was determined that the federal court didn't have jurisdiction. The Superior Court said, well, that court didn't have jurisdiction, therefore there's no valid conviction for section 109 to even apply. And then they mentioned in dicta and even sua sponte about section 112. So basically, these words can't be interpreted in a way that would basically make them meaningless. Separate from that, as Justice Bayer was mentioning, these statutes embody double jeopardy principles, and it is entirely inconsistent to say section 110 should be used, you should consider double jeopardy in section 110 to prevent a prosecution. But when you're looking at the exception, you make no consideration of whether or not the defendant has been placed in jeopardy of the offense that he's actually facing. Again, this would some very strange results of effectively, again, as Justice Bayer was saying, a defendant could pay off a traffic ticket in order to avoid the consequences of a very serious crime, like I mentioned in my brief, even murder. There's no real way to stop this. And again, that it seems very unlikely that that is what the legislature intended when it created the traffic court. It's much more likely that it intended, again, for these rules to encompass double jeopardy. So at the end of the day, if a defendant has been placed in double jeopardy, yes, section 112 or 110 should apply. The Commonwealth should not be able to go forth with the subsequent prosecution. If the defendant has not been placed in jeopardy, there shouldn't be this procedural loophole that allows them to get off the hook.
Counsel, Justice Donahue, what do you make of the title of section 110? For former prosecution before court lacking jurisdiction. Doesn't that give us some insight into what that section means?
So again, it doesn't say lacking jurisdiction over what, and I would say it doesn't give too much insight because the title is literally just emphasizing points 1 and 2, subsections 1 and 2. It's literally listing.
But it talks about a former prosecution before a court lacking jurisdiction. Doesn't that lead us to take a look at the former prosecution, not the subsequent prosecution?
Well, but then if you look at the actual text of the statute, it begins with talking about a prosecution is not at bar, and the prosecution that would be at bar is the subsequent prosecution.
A former prosecution was in a court which lacked jurisdiction over the defendant or the offense.
Yes, but I'm sorry, I did not mean to.
That's okay, go ahead.
The predicate language is a prosecution is not at bar within the meaning of sections 109 or sections 110. So above everything else, we're talking about a subsequent prosecution and when a subsequent prosecution is allowed. And again, looking at the title of the statute and all that, it can never overcome the legislature's intent. And it seems very unlikely that the legislature intended for this sort of interplay between the traffic court and compulsory joinder, especially in a way that ignores the double jeopardy principles that compulsory joinder is supposed to embody. There are no other questions. Again, I would just reiterate that the defendant's entire argument overlooks double jeopardy. These statutes are about double jeopardy. The defendant here has not been placed in jeopardy ever for his more serious crimes, and therefore the Commonwealth should not be barred from prosecuting him. Thank you.
Thank you. Thanks to both counsel. And with that, we'll adjourn court.
Thank you very much.
Thank you.